Hi, everyone. Thank you for joining us today. As you're coming in our webinar room, I want to welcome you. My name is Marche. I'm the webinar director here at Advice Chaser. And before we introduce our guests and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we are thrilled to bring you today's educational presentation. Attendees are muted, but we do encourage you to ask questions using the chat box, and the presenters will answer those queries during or after the webinar today as appropriate. If you ask a question in the chat box, go ahead and leave your phone number as well. And if we've not been able to get to your question during the presentation today, we'll make sure someone reaches out to you after today's event. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. I'd love to introduce you to our guests today. Mark Seither is a partner and wealth manager with Kingsview Partners in Knoxville, Tennessee. He has a Bachelor of Arts in Economics from San Diego State University and began working as a financial advisor in La Jolla, California. Mark enjoyed finding innovative solutions to clients' complex problems, and his desire to work with the entrepreneurial minded helped him thrive as a financial advisor. As Mark honed his skills as an advisor and a planner, he looked for a platform that would better pair with his desire to work with clients needing advanced planning and specialized fixes. He found his spot back in Northern California in early 2017 when he joined Trust CFO and assisted in integrating complex tax and estate planning with wealth and investment management. Since then, he has collaborated with Josh Saunders to build Kingsview Partners. Together, they assist individuals on wealth management and tax strategies. Mark, why don't you go ahead and come off of mute and say hello really quick so we can see who you are on the camera here.
Hey everyone, very excited for today's webinar. During my time at Trust CFO, we did, I worked very closely with trust administrators, and at that time, that's how I got introduced to Brian Bradley, because while trust administrators are good about knowing the very inner workings of operating some of these strategies, Brian was our go-to source of knowledge for more macro dynamic strategies. And so I have kept in touch with him, because when you meet someone like that, you want to make sure that you're always in their circle. So he's been a wealth of knowledge for me throughout the years, as well as a lot of my clients. So really excited to have him on.
Well, thank you for that hello from you, Mark. And I'm going to go ahead and introduce our speaker today. Brian T. Bradley Esquire is a nationally recognized asset protection attorney. Brian was selected to be the best attorneys on the Best Attorneys of America's list 2020, Lawyers of Distinction list 3 years in a row, 2018, 2019, and 2020, Super Lawyers Rising Star list of 2015, nominated to America's Top 100 High Stake Litigators list, and nominated to the 2017 Law Firm 500 Award. Brian also writes on high-end asset protection, and he and his team represent self-made entrepreneurs, professional athletes, business owners, medical doctors, real estate investors, those investing in cash flowing properties, and high net worth families. And we're really excited to be here with you today, Brian. And I'm going to go ahead and turn the time over to you.
All right, thanks. And thanks for, having me on, and thanks for joining us. And, like they said, I'm Brian T. Bradley, and Today, we're going to be talking about protecting your assets and the tools that we use to protect them. And so it's going to, it's filled with a lot of misconceptions and a lot of different areas. And so what we're going to do is try to break this down and give like an overall view of what's going on in the world, why we care, what's changed, what are these misconceptions that we're talking about, and then just break down a little bit more in detail, probably over like multiple segments, just not in one episode here. Or just the tools that we use and how we use them, and then we'll start putting the picture back together again. And then, collectively, our firm, we have over 3,000 clients nationally in every state, and we're protecting over, 5 billion worth of assets. And so my hope is that the key concepts that I talk about today will help all of you to better plan and take the preventative steps to protect yourselves. And now I'm going to talk about asset protection and a lot of the options, like I said, that exist. And I'm going to be clearing up a lot of these misconceptions. And so there's going to be a lot of information and knowledge that's brought, that we're going to be bringing to you today. So feel free to use the chat to ask questions, and I'll get to them as I can. Now, I talk on a lot of investment shows, and the constant takeaway really is that as investors, you're focusing on growing and adding to your portfolio and raising capital, closing deals, return on investments, analyzing metrics, but you don't think about what needs to get done to properly protect those assets. You don't look at the liability and legal risk and how you can lose it, generally until it's too late, meaning you're already being sued. So you need to care about that beforehand. And then most CPAs are not thinking about these concepts either. They're thinking about what a CPA should be thinking about, right? Tax mitigation strategies, not legal liability. That's when they refer you to people like me. So most of us don't even understand how we can lose our investments or where our liability and risk even are with our, our own businesses and in our personal lives and the assets that we actually own and are investing in. So we really need to take a look at it holistically, not just like piecemeal of I own a single piece of investment property in Tennessee, or I am just a doctor. We need to take a holistic look at how we can protect and limit risk and liability altogether, because we can get attacked from all over the place, right? That's what this talk is about today, the different layers and tools and strategies that exist to protect what you have built and are in the process of building, as well as the macro and micro views. There's more to this than just saying, here's an LLC, good luck. And so now the big question I think really is just, is asset protection necessary? And so let's just paint a picture of our current world. We're living in a fascinating time right now. We're seeing laws and policies drastically change every day, and people getting sued and being sued that normally wouldn't be getting sued. So protecting your assets, your wealth, and your legacy is more important now than ever. We have over 40 million lawsuits filed in the US each year. Plaintiffs' attorneys are constantly advertising for new targets, meaning you. The claims by former employees, if you own a business, along with employment law claims, harassment, discrimination, wage and hour claims are skyrocketing. The US legal fees are exceeding over 300 billion annually. And insurance companies are constantly denying claims now. They want your premiums, but don't want to pay you when you need them. And here's a quick example of this. Just a few weeks ago, I had a California client who's a medical doctor who has, $2 million in medical malpractice, had a $2 million umbrella policy on top of it, got sued for a $4 million medical malpractice lawsuit. Well, the medical malpractice provider covered their $2 million. The $2 million, coverage from the overage from the umbrella policy provider, they covered it, but then the umbrella policy provider decided to countersue the doctor to get the money back because they decided he should have gotten additional coverage on top of the umbrella, and they want the money back now. So then it really begs the question then, like, okay, what was the point of the umbrella policy? Why did I have that? And when does excess coverage actually then stop? That's where an asset protection plan actually starts increasing the protection that you have. So let's just start, I think, at the very basics, just like the sound of music. We got do, re, mi. My 6 and 4-year-old daughters are learning to play the piano and singing, and there's thousands of songs that you can learn, just by playing 3 basic notes, C, D, and E, or chords on a guitar. And so we also want to start at the very beginning here. So let's just start with, the basic definition, like what is asset protection and what are the key goals? Asset protection is simply creating a legal barrier between you and your assets. At its base core level, it really is anything that would protect an asset from a creditor. It really is that simple. It's like a safe that you want to put your valuables, like your guns and your jewelry, your watches and your gold, all tucked away safely into that safe. For example, if you're broke, you have nothing. That's one form of asset protection. You have nothing to get. So if you get sued, you got nothing to give them, right? And I'm a big believer in the Tony Robbins principle that success leaves clues. And if you want to be rich, mimic the rich. And so just like the rich, we want to have the benefit, the use, and the enjoyment of what you own while separating out the liability side of it. Rich people don't own things personally. They just use them. They enjoy them. They get the benefit from them. We want you to be able to go out and use your boat or your plane or your car, enjoy it, rent out those properties, build your portfolio. You just don't want to own it personally. Instead, your asset protection trust and business entities like LLCs and limited partnerships own it. The role of asset protection is simple. It's peace of mind and lifestyle preservation. You want less stress knowing your finances and your assets are safe. Asset protection planning is your modern best bet to level the playing field against this out of control legal system. And we do this by using all the different legal tools we have. And so our 2 biggest ones are either exemption planning and asset protection planning using LLCs, limited partnerships, and asset protection trusts, which we'll break down in different segments. But today, we're just going to be laying the foundation and talking about the first layer, the LLCs, and possibly limited partnerships if we can get to them. The first place we want to start with is just what is an exemption and what does exemption planning refer to? Exemption planning refers to the type of protection we get from state and federal laws that exempt assets from creditors. The creditor is valid, the claim is valid, the lawsuit is valid, the judgment is valid, but this asset is just not something they can collect on. And a few examples of these are, homestead exemptions, like in Florida, 100% of your home is exempt from lawsuits. Think of O.J. Simpson, the famous football player who got off, the murder charges for his, wife and the boyfriend. But then the family sued him civilly for wrongful death, and he lost that lawsuit, lost a multi-million-dollar lawsuit, but he was never able to be collected on, because his home was a Florida mansion with a homestead exemption, and the rest of his money was in his NFL pension, which was exempt as well, which goes to like ERISA 401k plans, which are federally protected, or your IRA plans, which are state protected. So they vary from state to state with IRAs. Same with life insurance and annuities, and then some assets through bankruptcy. The way that most exemptions are accessed, though, is through bankruptcy. So it has some limitations, and we really need to think about if you want and need to declare bankruptcy. So it's kind of a dance act that you play with exemptions. Now, asset protection planning is different. It does not rely on a state and federal statute to say, hey, these classes of assets are exempt. It just uses the legal tools like LLCs, trusts, and limited partnerships to limit the access of the asset to a creditor. And like I said, these are spendthrift limitations, spendthrift trust, which we'll break down in a different segment from this one. Charging order protection entities like LLCs and limited partnerships, or just locked up unreachable assets, meaning while the asset is locked up, let's say by debt, so some debt can be good, there's no access to the cash. And when you're getting sued, that's what the creditor is after, your cash, your equity value out of your home, the equity value out of your real estate investments, your non-exempt personal stock portfolio, your cryptocurrencies. So that's what they're coming after you for. So you may be asking me, all right, Brian, so which one is better, exemption planning or asset protection planning? You may be looking at the exemption status and think like, okay, that looks better. So why not just do an exemption planning all the time? But the drawback with exemption planning is that it can't just be arbitrarily expanded. You can't just say, okay, great, your state has all these exemptions. Let's just move all of your assets into them. And it's really hard to convert 100% of a client's assets. So then you need additional planning. The best practice procedure on all this would be to maximize exemption planning first, and then move on to asset protection planning, and then combining like domestic and offshore trust, which again, we'll be breaking that down extensively in later on segments when we start actually talking about trust and asset protection trust. And what this does when it's done right is that it makes it very hard for creditors to collect on you. And what we're concerned about at the end of the day is just collectability. Now you might be asking, okay, what's up with the legal system? What's changed? Why do I even care? Well, a heck of a lot has changed over the past 40 years. It's no longer about justice, but redistributing your wealth from the haves, which is you, to the have-nots. Now, for people who grew up with a more old school mindset, where lawsuits really were never an issue, back about 40 years ago, you could essentially have everything in your own personal name or in a family trust. That was acceptable then. You could get away with that 30 or more years ago. But over the past 40 years, the litigation landscape has just completely changed. Things that just didn't happen in the past, or that weren't even allowed to happen in the past, like contingency fee lawyers or law firm advertising, are commonplace now. And this created law firms that are purely sales and profit driven, representing clients with no skin in the game anymore, and they have nothing to lose. And the US doesn't have a if you lose, you pay system like other countries do. And so we have plaintiffs simply looking for a target to get a big payday out of, and a legal system that's not looking out for you. And we also have our own false sense of securities that we harvest ourselves. And I see that what is contributing to this false security comes from people thinking that they just don't need to do anything and they're just going to ride lady luck. But that's not a plan. That's just gambling and wishful thinking. Or that I'm going to deal with it when it comes up, meaning, okay, I'm going to get sued. I'll deal with this when I get sued. You're just too late and too far down the rabbit hole at that point in time. There's nothing I can really do for you at that time. Or they think that their insurance or umbrella policy will always cover them, which it won't. It's important to have insurance, and you need it, and you need good insurance. But we're getting more and more clients with claims that are radically in excess of their insurance coverage. So being underinsured is a big problem. And insurance just provides capital to fight. Or your insurance provider does what insurance companies do. They create legal wiggle room through claims of intentional acts and wrongdoings. And then they tell you that, we're not going to be covering you. And if you think that we're wrong, go ahead and sue us. So now you're left actually with two lawsuits, suing your insurance provider while also being sued. And a couple examples here are, we have another California resident, who's a doctor also, who purchased a New Jersey property, unknowingly rented out to a gang member. The gang member had a party, a fight broke out in the party, in the rental, guns were pulled, someone was shot and killed. Now who's getting sued? Mr. Deep Pockets white coat doctor who owns a property for negligence and wrongful death. And so now he's having to fight a multi-million-dollar loss of life lawsuit. Also there was a recent case in Louisiana with an Airbnb owner of an Airbnb short-term rental property where, what happens, Airbnb short-term rentals, people start partying and drinking. Well, some drunk decided to, be a genius at 2 a.m, ran out the backyard, did a head dive on a shallow pond on the property, broke his neck, became a quadriplegic, and then got awarded an $11 million judgment off of that. Mold claims also tend to turn into multi-million-dollar lawsuits. Deals falling apart if you're sponsoring deals and you're real estate investor or doctor starting to get into syndications and sponsoring large deals or commercial properties. So obviously, the more we have, the more risk we have, and then the type of classes and assets we're investing into carry a lot of risk with it beyond just our professional risk. And then we have the negligence of our life as well. And then we want to get, into the world of high net worth and affluent families and wealth. So at this level, we now have to deal with the macroeconomic global issues. The big picture really is that we have a global financial system that has structurally deep-rooted issues. along with government-backed fiat currencies that are now in question. And this also includes, as we're seeing, the US dollar. The monetary policy today is very plain and simple: inflate or die. And so with governments looking for deep and accessible pools of financing, meaning your money and your assets, and then we have, financial repression, monetary economic manipulation, it's just adding more and more challenges to protect and preserve your wealth. And so this is where a full and diversified asset protection plan really comes into play. And this is where we start going beyond just the LLC. So I think it really then begs the question, in the present hyper litigious climate, and all this global chaos, how confident are you really that, you're not going to be sued? And then how confident are you that if and when you are sued, the legal system is actually going to treat you fairly? How many people can confidently raise your hand and say, that you have the current planning and system and structure in place right now that's going to protect you? And so asset protection is, again, your modern best bet to level the playing field against these modern wealth destroyers. We're no longer talking about death taxes destroying family wealth, but predatory lawsuits, a broken system, divorce, and out of control medical costs. These are your modern day wealth destroyers. And so by using all the different legal tools we have, and that I'm going to break down shortly, what this does is it makes it very hard for creditors to collect on you. And when your planning is done properly, and when it's seen as being effective and impenetrable, this then puts you in a lot stronger position at the negotiating table. In fact, it generally chases most people completely away. I can't stop you from being sued. Nobody can. That just comes as a byproduct of success and increasing your visibility, and your holdings. But we can help with how collectible you are. This then puts you in that position of strength and gives you more legal leverage. The result of this is that you're going to radically deter the majority of those predators. And if you do get attacked or sued, you now have the proper tools and system in place beforehand by being proactive, to successfully protecting your assets. But this all has to be set up beforehand. And that's the big key word to take away: before it's needed, not after you're getting sued or you have a reasonable foreseeable expectation you're about to be sued. You're going to end up being happier, less stressed, more productive, since you'll have less fear about conducting your businesses, hiring, firing workers, contracting, investing, adding to your portfolio, syndicating deals, or even just sending your kids off to go drive, your cars. You're just going to have more peace of mind about your financial security. And
hey,
so,
Brian,
yeah.
We had one question come in. I did want to get to it because it was related to the exemption versus the asset protection. Someone did ask what the exemption status of homes were in the state of New York.
Every state's going to be different. Like the best ones, it's low. Texas and Florida have the best homestead exemptions. Florida 100%. So that, when you call into someone and have a consultation, that's why they're going to be asking you questions like, what state are you a resident of? They're just going to look up and get prepared before they talk to you. But states like New York, California, California actually did a really good thing. They actually increased the homestead exemption up a little bit now to like 600,000, but it's not like fully 600,000. There's like markers and step ups there. New York is going to be low. I don't know the exact number off the top of my head. I would look that up, because we got 50 states. So just realize when you call in for a consultation, that's one of the things that we're going to be talking about.
Perfect. Thank you.
Yeah, no problem. And I think that kind of like actually segues into, what are we looking at when we're trying to set up an asset protection plan, right? Now, for all this to work, I think 4 things have to be true. Your system must be seen as impenetrable. It must be managed properly. The plan cannot attract a lawyer to want to challenge it, thinking that they're going to get a payday. And then it just plain and simply must work. And as a client, we then know that you want 4 things. You want an effective plan. You want to control your plan. You want reasonable and sustainable cost. And you want a plan that's easy to maintain tax compliance on. Like if it's not effective, it's worthless. If you're not going to control your assets and keep investing, you're going to stop using it. If the costs are just way out of control and too high, then you're just not going to set it up. And if it's too confusing on an IRS tax maintenance compliance, after about 2 years, you're just going to give up on it. So, those are like, think about that acronym ECCC, or you can do ECCM, whichever way you want to break it down, but effectiveness, cost control, and maintenance, or effectiveness, cost control, compliance. Those are really the 4 things whenever you start vetting somebody on what they're creating for you. That's a great way to start analyzing what is the system that's being created for me. And so here's where we're going to go. I'm going to break down the tools that we use to accomplish all of this. And then I'm going to put it all back together again, probably in the last segment that we break this down, but we'll be doing it, like I said, over a few segments. But for a quick roadmap, we have the LLC, the limited liability company, the AMLP, which is an asset management limited partnership. So limited partners, we're talking about a family limited partnership, but when you use them for asset management, for asset protection, they're called asset management limited partnerships. And then asset protection trust. So let's just start breaking these tools down. When it comes to asset protection, we have different layers. I'm originally from the mountains in Lake Tahoe. We get lots of snow. I live in Oregon now. We have insane weather from, constantly raining, snowing, then the hot, then, an hour later. So we learn to dress in layers. The first layer is your foundation base layer. It generally is made from merino wool and it sits on your skin. This is your LLC. And then you want a mid layer, which is usually a little bit thicker, and it can be synthetic or wool, or for you ladies, a cardigan. This would be your limited partnership, your AMLP. And then you want an outer shell waterproof layer. This keeps you nice and dry and warm when the weather is really cold and bad. This is your asset protection trust. But by layering, you're now more flexible. When it gets hot and you're skiing, you can take the outer layer off, or the inner layer off, or the middle layer off. You can adjust to make yourself more comfortable. The same thing applies with your asset protection plan. The base layer is your LLC. It's going to be holding your risky assets like real estate investment properties. So that's where we're going to start today. So let's just start with the LLC. The LLC, again, is a great first layer. It's that entry place to start. It's the foundation along with insurance. LLCs are great asset holding companies. They have some charging order protection that don't allow the creditor to seize the assets of the entity. What they're trying to do is limit a creditor's access to a charge against the member or the partner's interest only. So they're great for real estate. We place things in them that have keys, or things that can go boom, things that can hurt people, things that you just need to go get insurance for. We place those dangerous things directly into an LLC. You can place all your risky assets in this LLC, but you want to separate asset holdings from operations and operate your business dealings out of another LLC called an operating company or a management company. So if you're considering just this first entry level protection, maybe you're just starting out investing, your net worth is under $500,000 net. You have only, 0 to 2 units or doors. You should just consider at minimum setting up 2 LLCs and get insurance, possibly an umbrella policy. But by using LLCs, what you're doing is limiting some of your personal liability. Again, some of your liability, LLCs, first word, first letter, limited, and separating ownership, use, and control. So if you're trying to protect just a few assets and money is limited for you, the LLC and insurance is a great place to start. And so even though I love LLCs and we use them to place those risky assets in them, like real estate and investment properties, and we use them to segregate assets in and put, car collections in, or your yacht, your plane, a boat, if you rent it out to people on an investment property. These are again, that great first layer of protection, but everything has kryptonite. And when you talk to Superman, kryptonite's not good. The LLCs lack on efficiency. So just remember that they're what's called maybe protection. And it says it straight in the name, first word, first letter, limited. They don't hide that fact. It's limited. And we have decades of case law that exists around this fact. This is the term piercing the corporate veil, meaning holding you personally liable, breaking through the charging order protection and through that operating agreement. Now, this is where I'm going to spend some time talking about these negatives that you're not told about LLCs, so that then you understand the limitations and then you understand the need to actually layer as you grow. So, because LLCs, again, are not silver bullet Dracula slayers. For real estate, we generally use the state that the asset is located in. I see some people recommending using one of the other states that are good for LLCs like Wyoming or Delaware or Nevada to physically hold the real estate in. The reality is that it's okay. It's not wrong. It's not a wrong thing. But if you have an investment property in, let's say, Tennessee, and it's held in a Wyoming LLC or a Delaware LLC, it's fine. But if you're sued through that Tennessee property and you have a lawsuit against that LLC, you can be very certain that the Tennessee court is going to apply Tennessee law to that LLC that's holding that Tennessee real estate, not Wyoming or Delaware law. So if you think that you're buying another state's or jurisdiction's better laws by having an out-of-state LLC own an in-state asset, I don't think that's true. And you can't be certain either, and lack of certainty is not good. So we typically just say, use an LLC that the asset is in, or that the boat is registered in, where the hangar's at. And we also like to separate assets. We don't use too much, we don't want to put too much assets or equity in one LLC. So I don't want to see 10 single family residents in one LLC or millions of dollars worth of equity in one LLC. For example, I had, one California client with 5 investment properties, all over 1 million in equity each. So each property is, equity value 1 million each, all being held in one LLC. Then they got $1 million lawsuit mold claim against them. So now all those assets are now at risk. So what you want to do is take $1 million property and separate them out into their own LLCs. Now, if the equity was lower, let's say $100,000 per property, then you can probably place 4 of those single family resident properties into one LLC, but I wouldn't do any more than 4 because now you're inviting a lot of risk. Another problem generally is that most clients come to me with 15 LLCs, and they're all single member LLCs, and they're all disregarded entities and all in the client's personal name as members. Now you have a problem from an asset protection standpoint, because the courts have a tendency to disregard those single member LLCs held as an individual, meaning you. And CPAs tend to set up LLCs as disregarded entities for tax purposes. That's great for taxes, but really bad for lawsuits. Or they set up S corps for real estate. And that's another bad thing to be doing when it comes to real estate. One reason is because S corps have shares, and those shares can be frozen or seized by a judge. And I actually get this a lot. If you come to me with real estate in an S corp, and let's say you have $100 million worth of real estate within one S corp, or it can be other assets like truck beds or medical equipment, whatever the S corp's holding. From a liability and asset protection standpoint, it's not good. We prefer to move those assets out of the S corp and put them into LLCs, then lease them back to the company. But we wouldn't want to do that at that point in time without you having to need to pay a huge tax recapture fee to the IRS. And so now we're stuck. And this could have all been avoided if the planning was set up properly from the beginning to grow with. And this is where the client, your CPA, your wealth managers, and the asset protection attorneys need to all talk together from the beginning. But to get back to being disregarded, what an LLC being disregarded means is that the IRS is not taxing your business separate from you. It passes through to you personally. And because of this, they're basically worthless for asset protection and liability issues, because by being disregarded, that liability also passes directly through to you. But don't get me wrong, I still use them, but as that base layer foundation, that entry level protection. Then we build and add layers of strength above that. What you actually want is for that single member LLC that's holding your real estate, to then be owned not by the individual, but by a second layer of protection, which should be a multi-membered limited partnership, that AMLP, not an LLC. And I'll break that down in the benefits of limited partnerships later, maybe, if we have time to reach upon that today. But by doing this, what you're now doing is properly layering your protection. Your mid-layer, the limited partnership, will be owning all those LLCs that are holding your real estate. Your asset protection trust will be owning that limited partnership. You'll be the managing member of the limited partnership. And so all those LLC tax filings and the K1s will simply passively flow directly through to the management company, that AMLP. So you now just have one tax filing. What we're doing is maintaining the legal protection, but we're disregarding them for tax purposes, creating a really smooth and easy transition for fewer tax returns by adding that second layer, the limited partnership. And so it really just comes down to how you use all of them together. And the second really big misconception people have with LLCs is just, like, where do you even go to set these LLCs up in? Do you go to Delaware, Wyoming, Texas, Nevada? And you hear about all these states, and some of these states have privacy. And so, people say like, oh, I'm just going to go do that. Well, in reality, it really comes down to an issue of just what are you holding and where are you holding it at? But I think I've covered that pretty well. Just realize that, let's say, for example, it's California real estate, and you set up a Wyoming LLC, and then you bring it to California by holding a key piece of California real estate in it. And now that client's paying the California franchise tax because they're a resident of California. What's happened is that they've converted that Wyoming LLC to a California LLC because they're doing business in the state of California. That's the state the asset is in, that real estate is in. That's the state that injury or damage occurred in through that property. It's going to be that state's laws that apply. And once you do that, you did this fancy legal word called availed yourself of the privileges and laws of that state and given that state jurisdiction over your out-of-state, LLC. Then it's just a matter of applying basic corporate veil piercing strategies. And then we have the final big misconception of LLCs, and that is anonymity. And the thought here is that you can just, create an anonymous Wyoming LLC and you just poof, disappear and can never be found. That the LLC member's name is not available to the public, and now you can completely avoiding ghost a lawsuit. This is just completely false. But this is what you're hearing on investment groups and summits, and what you're being told from promoters and even some attorneys. And so these people do these big long talks with hiding assets and special operating agreements. And though they're not technically lying, if you get a judgment against you and you get called into a debtor's examination in court, you're the one that's going to have to tell them, you're the weak link here in that line of secrecy. So under oath, you're going to have to tell them that, yeah, I set up that Wyoming LLC. And now your privacy plan just exploded. And so privacy is fine, but secrecy and hiding is not. Wyoming LLCs have their place in the asset protection world as a first line of defense for business owners, for privacy, and not placing yourselves at risk of harm and harassment. But it's a privacy mechanism before lawsuits start. But this doesn't mean that your identity can't be found, or that when your LLC is sued, that you won't be legally required to appear and defend your LLC. Wyoming and Delaware LLCs and out-of-state LLCs require personal agents of service. Their sole job is to literally serve you and tell you, hey, Mark, congratulations, you just got sued. Now go get a lawyer and defend yourself in court. The simple reality is that once a lawsuit is filed, the discovery process of litigation begins, and you will be served. You will be subpoenaed. You will be forced into court. And what's even worse is that if you want secrecy to even work, also known as lying under oath, and then you tell the court that you don't own anything, that's a one-way ticket to jail. An example of this is what I mentioned above, that very shortly after a judgment's entered against a person, creditors have the legal right to demand information about the assets you own. And the courts enforce this right very broadly. So at this point in litigation, the only way to keep an asset anonymous or a secret is to then lie about them and commit perjury. We don't advocate for hiding. We just prefer to have a full disclosure of a proper asset protection plan and just set it up properly to work. So for assets that are real estate, we recommend using the state that the real estate is located in because again, you're not gaining anything by using another state. You're just doubling the maintenance cost. You just can't buy another state's laws, for out-of-state assets. So just keep it simple and then add layers to the protection system as you grow. Just remember, the weakness with LLCs is that it's still just maybe protection. Maybe it will be upheld, maybe not. Maybe the judge will pierce the veil, maybe not. And we know, we already know about piercing the veil. So there's a lot of uncertainty, and uncertainty again is not good, especially when strength and power is important. So I'm not sure, if you guys want me to break down, quickly the limited partnership or not, or how we're doing for time.
We're doing great on time.
I was going to say, I think we're doing great on time. I think we can touch on the limited partnership and then just kind of tease, the concept of asset protection trusts, and then do a follow-up with that.
So, that's going to bring us then to the second tool, or layer, the AMLP, the Asset Management Limited Partnership. This layer comes into play around 450,000 to 700,000 of unprotected net. And what unprotected net assets means, it's not exempt assets. Like I'm taking 401ks out of the equation, IRAs out of the equation. I'm looking at equity, not market value. If you have $1 million value property and you only have, own 20% of it, well, really you only have $200,000 worth of equity there. So when we're talking about unprotected and net value and assets, that's what I'm looking at. And generally you have 4 different properties around this stage, probably maybe in a couple of different states, plus your primary residence, along with personal stock, your personal brokerage account that's growing. It's similar, limited partnerships are similar to an LLC in that it has a layer of protection around it to limit your liability. And they have some charging order protection, and built-in statutory privacy, which is nice. This mid layer is your holding company. And it's the mid layer where you actually do want to use one of those states that has really good protection around the LLCs like Arizona, Nevada, Wyoming, or Delaware. This mid layer protection should be a multi-member entity, whereas that base layer LLC, that entry layer that we just talked about, can be a single member LLC, because remember, at that base level layer, that single member LLC is going to be disregarded for tax purposes. But as you stage and grow your protection and we add that limited partnership, you want those LLCs disregarded for tax purposes, because when a client comes to me with 15 pieces of real estate or with 10 LLCs, we don't want you to have to do 10 separate tax filing returns and 10 separate K1s. So by making those base layer LLCs single member LLCs, it helps with tax filings, because we add the mid layer asset management limited partnership, because then all those K1s flow directly through to the management company. So it's just one tax return filing. But the AMLP is a step up from an LLC, since it also works very well as an asset holding company, because it has 2 different classes of ownership that an LLC just doesn't have. LPs have a general partnership interest and a limited partnership interest. Just like, draw a circle, put a line down the middle of it, and it has like split personalities. On the left side is the GP, on the right side is the LP side of it. The GP is going to be the managing member. The limited partnership side, the LP, is going to be what actually owns that limited partnership. And the limited minority partnership is going to be owned by your asset protection trust as you scale into this type of planning, and that's the ownership interest. But dividing it up like this, you get a separation of ownership and control. And remember, asset protection is about what? Separation, strength, and power. You just can't get this with an LLC. But unfortunately, I see this a lot with clients having the second layer of protection being another LLC or like a Wyoming LLC and not a limited partnership. We use Arizona as the limited partnership and that starting point for clients at that mid layer, that second layer holding company, the Carnegie layer, and then add the bridge trust, like a very strong asset protection trust to it for the actual strong component. One of the main reasons we use Arizona for the limited partnership is because of ARS section 29-333. This section specifically allows for a limited partnership to take to make a unilateral withdrawal from the limited partnerships on the occurrence of a predefined event. So like a lawsuit or a big lawsuit, a doomsday lawsuit. And this is specifically unique, that unilateral withdrawal to Arizona, and becomes very handy when it comes to that third layer asset protection trust to the limited partnership, because it allows the trust to disconnect from the holding company during a time of duress, or that doomsday lawsuit. So it can demand all that, the trust can then demand all the assets, disconnect from the limited partnership, and then disappear. This just can't be done with an LLC. You can try to be very creative with an operating agreement, but then those operating agreements are left to judicial interpretation versus actually having a specific statute by law, by legislature granting this. And I want to spend like a little bit more time on this mid layer, the limited partnership, and why it's a limited partnerships, and specifically Arizona. Beyond the distinction between the managing partner and the minority partner, some of the other specific reasons I prefer an Arizona limited partnership over a Wyoming LLC or others are: you have exclusive charging order protection in Arizona as the only remedy for creditors, of a partnership. You have an actual statutory distinction between general partners and limited partners by statute. This is better than LLCs because LLCs can only do this by an operating agreement that's then going to be left to, court and judicial interpretation. So again, we also have ARS section 29-333 that allows for that unilateral withdrawal and disconnecting, which just can't be done at all with LLCs without exposing you to a claim of fraudulent transfer. And, just that alone is already going to be a good list, but then just a few others are: the Arizona limited partnership is perpetual, whereas every other states have an annual report or filing for LLCs. Arizona does not require listing the limited partners. You only need to list the general partners. So by their nature, limited partnerships are completely private. And then for tax filing purposes, your limited partnership cannot be a disregarded entity. But LLCs with just one member are automatically considered a disregarded entity. And remember, being disregarded is not good for liability issues and lawsuits. And so the way the limited partnership works is that all the LLCs that you create to hold your risky assets in, like real estate investment properties, are going to be owned by that limited partnership. They're going to be owned by that AMLP, along with, you can put cash, stocks, bonds, passive syndication deals in there. Whatever safe assets you have that are non-risky can go directly into that AMLP now. The way ownership and control gets set up is that the general partner of that AMLP, which can be you or it can be a Wyoming LLC, is going to be the managing partner. And that now gives you control and privacy. The minority limited partner is going to be your asset protection trust, or like specifically a bridge trust. And that's where the asset protection component really comes and connects and kicks in. That's why I like AMLPs or limited partnerships over an LLC at that second mid-layer level. You just have so many additional protection mechanisms statutorily built into limited partnerships. But it's really is the combination of the two working together, the limited partnership and the asset protection trust, that you really want to capitalize on.
All right, can we touch really quick on this? I know we're going to do a separate webinar just about the asset protection trust, but maybe if you can just define what it is really quickly, and then we'll go ahead and move on to questions.
Yeah, and so, we broke down the first two layers, the LLCs, the foundation piece, then the second layer, which is a limited partnership and as a management company. That then brings you to the third tool, the third layer, which would be, that outer shell, bad, weather layer. It's the dead of winter, the frozen tundra, you're in Siberia, your world's falling apart on you. It's the asset protection trust. And asset protection trusts are the heart and soul of the system. Now, trusts come in like a million shapes, sizes, and flavors. So that's why we're going to actually spend probably like a good 30, 40 minutes in the next segment breaking down just trust. What are trusts? What's the difference between a revocable living trust and an asset protection trust? What's the difference between, grantor status? Why grantor status? And so it's going to take a lot of information to break down, the world of trusts and how they're played. But just remember, asset protection trusts are not revocable living trusts. They're not estate plans. They're trusts that are designed for you, by you as your own beneficiary, because they're self-settled and they're designed to protect you from lawsuits while you're living. You know, revocable living trusts are completely different. They're estate planning tools to go into effect when you die and pass to avoid probate and death taxes. And so they're just completely different animals. And so that's why we're going to spend a lot more time breaking down asset protection trusts.
All right, looking forward to that.
Perfect. Yes.
Mark, I'm going to turn the time over to you, and you're going to go ahead and see if we can address some of these questions that have come in.
Yeah, we had some other questions come in, and we've just been saving them to the end. Some of them are from early on in the presentation. So Brian, we had a few come in on umbrella policies. One person asked, so are umbrella policies still worth it if they can try and get out of claims or countersue you?
Yeah, everything is worth it. Just remember the pros and cons of everything. Something's better than nothing, right? And so you should have insurance, have good insurance, level up your insurance as you go and grow. Umbrella policies will add more capital to fight. Just remember, insurance companies are businesses. And so businesses don't make money by paying out large claims all the time. That's why there are these wonderful things called insurance defense attorneys and firms that represent just the interest of the insurance company. So have it, know its limitations, read your policy, know what your claim amount is, and then know, and realize it's good for little things. Big things, umbrella policies will provide more capital, but team it up with your asset protection plan.
Yeah. And then there was a follow-up to that too, as far as where can someone go to see if there are either loopholes or red flags in their current insurance?
You can talk to, really, I'm not going to be reviewing your insurance, company. I would just talk to an attorney and maybe an insurance attorney and say, hey, can you walk through and explain to me my insurance policy and what's covered and not? And then you should be doing that as well, like when you're shopping around for insurance and just understanding, what are the loopholes, because when you go to an insurance provider, it's a negotiation. So you should know what you're negotiating for and what you're giving away or not. Ask for things. Problem is, you probably don't even know what to ask for.
Yeah, and I know a good place the person who asked that question, a good place that you can start is just going to your exclusions. Yeah. Right. So, in that case, it's not really a loophole because they're pretty out in the open about like, hey, these are the things we're not going to cover. These are the things that, are still going to be on you.
Yeah. And then you should just ask like, okay, what changes in the premium or the coverage if we do include this or the amount? So remember, it's a negotiation.
Yeah. Which, I mean, not necessarily on umbrella policies, but, I did have a small story of someone who it was just their homeowner's insurance. Right. Yeah. And, he got cheaper homeowner insurance and he had a slow leak and it wasn't covered. And his insurance provider was like, oh, well, if you had upgraded, we would have covered slow leaks and sudden bursts. Yeah. Right. So those are some of the things that you ask your insurance company is like, hey, how much is it going to cost to take on more risk for you guys?
Yeah.
And then another person was asking, does it make sense for just having an LLC per property that you own?
It depends. Like sometimes it's overkill. It just depends on the type of property, the equity that's in it. Some people do go extreme and just put a piece of, one piece of real estate per LLC. Some people go the opposite end of extreme and put like 10, 20 in one LLC. There's a fine dance, really, and I try to say, like, generally I try to cut it at 500,000 of equity and no more than four doors. And that way you keep the risk down and the amount of equity down. Sometimes it's just impossible to do that. Depending on where you're investing, if you're on the coast, East Coast, West Coast, property is expensive. So sometimes it's impossible to find a property that's less than $1 million, or if it's commercial, that's different. That's not a residence. Commercial property should be in its own LLC. Or if you have multi-units and you're investing in, 8-plex, 10-plex, 15-plex, 100-plex, that should go in its own LLC.
Yeah. And then this, so for the person asking this, you're not the first one to ask this. Someone asked, hey, could I transfer properties into an LLC owned by my spouse?
Yeah. And you ask, and remind me on this one, the dual and sales clause. So just let's not forget to ask that one as a question. If it's owned by your spouse, it depends. Like, do you have a prenup? Do you have a post-nup agreement? What state are you in? generally it's going to be deemed community property. And so if it's bought during the communal marriage, there's a presumption it's going to be community property. Who's on deed? You know, if your spouse took the loan out in their own name and you're on the deed anyways, well, thank your spouse, give them a big hug and kiss. And they just gifted you, you know, title of the house. And so just realize, yeah, you should, your primary is not going to go into an LLC to begin with. It's going to go into an asset protection trust. Otherwise you start messing with your, you know, tax benefits and credits and write-offs and all of that. So just realize investment properties, if it's communal and it's not separate assets that's coming to the table before marriage and there's no prenup or postnup, it's just going to be, it's all going to be protected into the, you know, same marital asset protection plan.
Okay. And then for the you know, another question on the AMLPs, someone was asking what are the expected annual costs for, you know, getting into this kind of planning?
So yeah, like generally, if you're going to do like a limited partnership and an LLC, limited partnerships on average, you'll find go, you know, from law firms that are setting up pretty well, you know, good you're going to a law firm to do it, about 6,000 on average. LLCs, you're going to find on average around 1,500 if you're having, you know, an actual asset protection law firm, you know, attorney draft it for you. So just think about if you're doing, let's just say you're at that mid-layer level and you need a limited partnership and 2 LLCs, you know, plan and budget for about 9,000.
Okay.
And then one thing I wanted to touch upon was that due on sale clause.
Yeah. I was about to ask if you could touch on that. Yeah.
So, you know, you get this a lot of like, oh, what about the due on sales clause? And if I hear that if I transfer title into an LLC, the bank's going to call my mortgage due. Can they? Yeah. Have they? No. I have managed hundreds of attorneys and law firms nationwide, and over, you know, 30 years, not me or any firm and attorney that we affiliate with have ever found a case where a bank is going to call a mortgage due because you transfer your investment property into an LLC. Most of the time, they actually ask you to create an LLC. And so it's not a matter of what you can do. If you involve the lender, it's a matter of what they're comfortable doing. So we don't involve the lenders at all. If you're using a trust, it doesn't matter. It's exempt. So you can transfer property that's owned by a trust. If you're not using a trust and just putting into an LLC, we don't involve the lenders at all. We just transfer it. And if they ask a question, we just tell them it's an LLC for asset protection. Our clients, you know, the managing member or their limited partnership is, and they say, okay, great, thanks.
Perfect.
All right. Well, I want to tell both Mark and Brian, thank you so much for this really informative webinar. And now we've got more to go, so we're looking forward to that. But this has been a really, really great start. So again, I want to thank the organizations that have made this webinar possible today. To our attendees, thank you so much for attending, and look for an email soon with a link to the replay of this event, and you're welcome to share that replay with your friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming, and we'll see you at another webinar soon. Bye, everyone.
Perfect. Thank you.
Thank you.